everyone. Welcome back to another episode of the Ask Amity Show. Today we want to talk about small business interests. It's a really important topic. As you know, lots of people have small businesses. America's economy is made up of majority of small businesses. So we know there's a lot of small business owners out there and there's high interest in this subject. So how do we avoid your small business going into probate upon your passing? So avoiding this means, you need to start planning now. And that is by creating a living trust. A living trust can help the business continue to function smoothly after your passing. If these interests are tied up in probate, it can result in your executor having to operate the business under the supervision of the court. So that is definitely the last place you want your business to be in upon your passing. You don't want the court or a judge who has no skill in running the business and really does not have your interest or your heirs' interest when they're supervising these type of cases. So a living trust allows you to quickly transfer ownership to your chosen beneficiaries so that they can run the business without any interruptions caused by probate. There will be different issues to consider depending on the type of business organization you are transferring ownership of to your living trust. So Jennifer, why don't you start us off?
Sure. So it depends on the type of business, right? So there are different type of structures when you begin your business or when you're running your business. The first thing being perhaps you have a partnership. So if your business is operating in conjunction with partners, perhaps you may have like a partnership agreement. The first thing we would do is take a look at that partnership agreement and see if there are any restrictions with transferring your ownership interest into a living trust. These type of restrictions should be pretty rare because for the most part, transferring into your living trust essentially is the same thing as if you're running the business on your own. So there should be no interruption in terms of transferring the partnership interest into your own living trust. What we would do is, we would change your partnership certificate to note that the trust ownership basically owns the share that you own as a partner. So if you're 50-50 with another individual, then we would create the trust or the partnership agreement to show that now your trust owns that 50%. So in case something were to happen to you, then that 50% ownership interest would go smoothly through your trust to your designated beneficiary.
And for limited liability companies, so to transfer ownership to your trust, if you operate as an LLC, typically requires the approval of either a majority of or the totality of all the other owners of the LLC. So it may be advisable to change your trust document to provide that you have the specific ability to become involved with the business of that limited liability company.
And then another type of common entity that we see are corporations. So how we transfer corporate stock interest would be through a stock power transfer. This would be signed by the actual shareholders themselves into their living trust. What we would generally do is if the clients already have their stock certificates previously issued to them, we would issue new stock certificates, and these would be named into the trust. And the new stock certificates typically would need to be signed by the secretary of that corporation. Another common type of entity would be professional corporations, like for attorneys, for doctors. This type of corporation cannot be transferred because it's tied to your license and your degree. So it's difficult for those corporate stock share interests to be transferred. So we would generally not transfer those. What you can do is if this professional corporation has a bank account, then we would just advise that you name the trust as the account beneficiary. Perhaps if you're a sole, doctor, a solo professional, and you own this professional corporation solely, that could be a method of making sure any assets, bank accounts, cash, account receivables that you receive into this professional corporation has a beneficiary listed on the account.
A similar rule goes for a sole proprietorship. So you want to make sure that any bank accounts in the name of the business names the trust as a beneficiary as well.
And so, I mean, all of these kind of entities, we typically would talk in depth with our clients to really fully understand the situation, the type of business, the type of entity. And then, we do advise you to talk in depth with us before you do make any changes, just to make sure that you're not, handling things where there are certain restrictions with other shareholders, other partners that you may have agreed upon with them in the past. So again, we're here for you. We love speaking with you. Anytime you need us for your estate planning needs, feel free to reach out to us here at Amity Law Group. Thank you, guys.